The council, as you see before you, were delegated and empowered with the authority to consider submissions and make recommendations to council on the adoption of the bylaw. There are no apologies. Also note that we have QLDC legal counsel Mary Davenport also joining via Zoom. Any declarations of conflict of interest?
No. From me.
Just a confirmation of the agenda. I'm happy to move that the agenda be confirmed without additional alteration. Do I have a seconder? Thank you, Councillor White. So, now we move to the summary from the reporting officer. So, Carrie.
Tina Koto Kathroa, Co-Chair Williams, I am the policy manager. I lead the review of the bylaw. I'm joined by Anthony Paulo and Isabel Logas from the monitoring and enforcement team. So they're the subject matter experts on the bylaw. I'd like to take the report as read. I would like to point out the submissions in the hearing report reflect that the views on this issue are not on a spectrum. They are at opposite ends of the spectrum. They're polarized. And also just a very brief introduction to the framework within which this issue exists. So submissions also reflected substantial scrutiny of the Prostitution Reform Act. Council's role here is limited to determining whether it would like to regulate this issue via bylaw and how, or via the district plan. It's not open to the council to prohibit bylaws. And it is bound to the act that decriminalizes sex work and mandates that there's a framework for sex workers to work safely within. Before we turn to hearing submitters, I just want to make two minor clarifications that arose in the submissions. There was submissions around the use of the word slightly expanded to reflect the draft bylaw that was adopted for consultation. That was deliberate. I recognize that it was a doubling in size of the current area, but in relation to the other options that exist, it is slight. So that was deliberate. The other point, it was pointed out that the draft bylaw, it didn't appear to have the proposed new map in it. And that's a deficiency that I've noticed in track changes. You delete text and it puts a strike through. If you delete a map, it stays there. So there was a perception from submitters that we hadn't put a new map in the draft bylaw. It was actually underneath, but the old one appeared above it. So just to clarify for councillors that we'll note that for future to put a manual X through what the proposed changes to figures and maps. So that's lesson learned from Word for me. Happy to answer any questions from councillors, otherwise turn to the schedule of speakers.
Do you have any questions from basic staff before we move to hearing discussions?
Not at this time.
Do we have the opportunity to ask some questions afterwards? Deliberations.
I would just, yeah. All right, I'm happy to move to the hearing of submissions. I'd like to introduce Dame Catherine Healy from Aotearoa New Zealand Sex Workers Collective. Thank you for coming along, and you have 5 minutes when you're ready.
Kia ora koutou katoa. I wish I was there in person in that gorgeous town, actually. But I do have family who live there, luckily. I've spent 37 years working for the sex worker rights-based movement, and previously I was a sex worker, and it's 21 years today that the Prostitution Reform Act was passed by a margin of 1, and since that time we've worked quite a lot with councils and worked on the location of brothels. And I like to think we have at the heart of this debate from all sides, albeit, from the opposition to what we believe the rights and safety and health and well-being of sex workers. In your town, there are a number of sex workers who are working in breach of the bylaw. Some may know this, some don't. We periodically hear reports from sex workers when they have to reach out for support from the police. And so, the police have been good in terms of responding. However, it can be an impediment for some if they're working in breach of the bylaw. It's a fear that they're going to have to overcome and step over a regulation, a bylaw that potentially has the it can harm them, actually, put an impediment to them coming forward to report crimes committed against them. We note that coming back into the bigger picture in respect to councils around the country, when the law changed those 21 years ago, councils reacted quite strongly and have become over time far more liberal. Most recently, Rotorua and Upper Hutt City Councils decided to go with a more liberal approach. They had similar bylaws to what you currently have. They talked about sensitive sites, or Upper Hutt did, and you know, churches, marae, that sort of thing, that, you know, brothels couldn't be located near these sites. And of course, you know, we know that sex workers are part of these other activities. They visit marae, they go to church, they, you know, are moving amongst your community. So they're not people to be feared. What is to be feared is a bylaw that restricts people coming forward. And, you know, we would like to see your bylaw more liberal in its approach, so that sex workers can be self-governing. At the moment, your bylaw is incredibly restrictive, and you would have to have a lot of money, and generally the people with a lot of money are the operators of the venues. And, you know, single sex workers or sex workers who are buddying up with friends can't afford to operate in that contested area. It's impossible. So essentially you're forced, you know, by the presence of this bylaw, those sex workers to work in breach, and that is a problem. We know from evidence that, you know, we've had lots of researchers crawling all over the Prostitution Reform Act from, you know, lots of different countries, lots of universities in this country, and we have compelling evidence that speaks to sex workers working within the confines of good legislation, not being ostracised by it, and that equates with a good outcome for their occupational safety and health. Of course, you know, there are coercive situations, and it's really important that sex workers aren't cut off from reporting those coercive situations, but having a bylaw that is so restrictive and hostile to sex workers doesn't mean that, you know, you're going to get rid of those hostile, you know, those coercive situations. It does mean that you lock sex workers down and prevent them from coming forward. So I beg you to consider liberalising this bylaw, and above all, we'd like to see it tucked into the district plan. Do away with it, but that might, you know, be the next round when it's reviewed again. So thank you for this opportunity, and if you have any questions, I'm here probably for 30 more seconds, is it?
10 seconds, so very well timed. Just a quick brief, do we have any quick questions?
Can I ask a question?
Yes.
When you talk about wanting it to be more liberal, what do you refer to? Like what would be your ideal? Obviously, we're reasonably restricted today on what we can and can't do, but what is the ideal for you?
Well, the ideal would be that sex workers are treated like other occupational groups and have the option to work in a managed setting if you know, which they do have, or work in a home-based occupation setting, you know, buddy up with a friend, you know, so that they can work from home and have the security of working with another if they so choose. Most actually don't. They prefer to just, you know, work quietly from their own home or apartment, or meet clients through a motel setting. But, you know, to have the option, we think, is really important, and to make sure that it's not concentrated just in one residential area, that there is more potential for people to work wherever you allow work to occur in home-based settings.
Awesome.
Thank you.
Thank you very much for speaking today, Catherine. I really appreciate it. And you're welcome to hang around online or do as you please from now. But Yeah, thanks so much.
Thank you.
I'll just note that our next speaker, Dana Burton, has fallen ill and isn't able to come through. So do we have Jennifer Scott? Yes, I'll move to you if you're okay to start speaking, Jennifer. Jennifer, are you happy to do your submission now, if that works with you?
Hello, hi. Hello, my name is Jennifer Scott and I'm a representative of Suffragettes NZ. The Suffragettes have historically worked hard to protect the rights of women and children in New Zealand. I'm speaking today in opposition of the bylaw put forward to Council to extend the areas that brothels can operate in the Queenstown and Wanaka Business District. We choose option 3 that is being offered, no changes to the bylaw. The areas of concern written in the statement of proposal for the draft Brothel Control Bylaw 2024 are that it is to provide a larger area within which brothel activity is permitted, enable commercial sexual service providers to operate within the district in a manner that meets market demand for services, and removal of the restriction that brothels may not be located at or below ground level. In the Prostitution Reform Act of 2003, there is a framework that safeguards the human rights of sex workers and protects them from exploitation, promotes the welfare and occupational health and safety of sex workers, creates an environment that is conducive to public health, protects children from exploitation in relation to prostitution. Firstly, I would like to point out, regardless of what the Prostitution Reform Act says, and also that of Catherine Healy, the spokesperson for New Zealand Sex Workers Collective, is that sex work is actually the selling of an individual's body for sexual pleasure. The bodies for sale are mostly that of females, women, and the market demand is that of a buyer, which is in most circumstances is a male. Extending the areas for buyers to pay women for sex is not the answer. Council members and local residents should be aware that buyers of sex are not going to stay within an allocated area, and if it was made larger, this will extend further into residential areas. We would not want sex offenders and addicts to approach young girls or children because business for brothels in the area have been enlarged, would we? I note that in the ODT article published in May, Ms. Healy states that the selling of people's bodies is business, and that those who were selling their bodies to buyers outside of the current controlled area were reluctant to report situations to police, implying that buyers are already asking women for paid sex outside of brothel areas. In the proposal, there is the removal of the brothel area being at ground level or below ground level. How is this protecting youth and young children from being exposed to prostitution? This restriction was obviously to have such activities held upstairs in order to prevent the sale and advertising of sexual exploitation being exposed to public viewing. It was written that Council has received 8 complaints of alleged operation of brothels outside of the permitted activity areas in the bylaw in the last 5 years since 2018, of which 6 related to valid breaches of the bylaw. However, no prosecutions or enforcement action took place. Please note, these were complaints made by concerned individuals in the area and not a call for making more brothels. As women, we know of the negative impacts of prostitution and can speak to the facts and the known dangers of this business. The word sex work is used to disguise the truth of the operation. This is not work, not labour, it's abuse. Punters, buyers are more likely to commit rape and sexual violence than other men. Anything that increases prostitution will inevitably lead to more male violence against women and girls. It sends out a loud message. There's nothing wrong with buying sex. So more men buy sex, more brothels get set up, they need more girls to fill the brothels, and women who actually have other options seldom choose prostitution, so the sex traffickers move in to fill the gap. A report published in December 2016 by Dr. Christina Stringer entitled Worker Exploitation in New Zealand, A Troubling Landscape. The report highlights the key industries in New Zealand where worker exploitation is taking place. A key area mentioned was prostitution. New Zealand studies have found that girls as young as 12 are being forced into prostitution. By going ahead with this bylaw to enlarge the area for brothels in a once quiet and family-friendly town, you not only open the door to human trafficking, but also you will be taking revenue from the businesses through rates from selling of women's bodies. Therefore, the councils will be wholly responsible for any harms placed onto women and children in the local area. Thank you, and I'm open to any questions.
Awesome. Thank you very much, Jenna, for a really well-timed speech. So unfortunately, we may move on to the next speaker. That's okay. Okay, so no questions.
Thank you.
Thank you very much for your time, Jennifer. Much appreciated.
Thank you.
All right. So we now move on to Janet from Women's Declaration International New Zealand. Do we have Janet online? Yes. Janet, are you comfortable to speak now? Break the ice. This is the first time we've had a hearings panel where all of our speakers have been online. So I don't know if that's like a record or a small trophy, but yeah, that's a very widespread issue. But Janet, are you available to speak now? I appreciate that it's a minute or so earlier than really.
Janet indicated she's trying to unmute.
Trying to unmute. Okay, cool. We'll allow you to do that. Don't I assume you've asked
She's having trouble with unmuting. I can't do it.
on the top right of that, if you highlight over her square, the ask to unmute, just click that, see if that helps her out.
Yeah.
Yeah, happy to. I respect that that's pretty stressful. So it looks like we have Bob McCoskrie here and available to speak. You can just confirm, Bob, that you're happy to move your time forward just to make allowances for technical difficulties. Seeing as I can see you, it sounds good. You're welcome to start in 5 minutes when you're free.
Okay, thank you for your time. Nice to be on early, and I'm sorry I can't be there in person. It's slightly warmer up here in Auckland. The sad reality is that prostitution industry is harmful and dangerous, despite attempts by the Prostitutes Collective to paint it as otherwise. And more vulnerable people are becoming victims because of the law around prostitution. Despite the sales pitch I'm sure you've received, prostitution work is high risk and it's harmful based on official statistics and the testimonies of women who have managed to exit the industry. Decriminalisation has failed to achieve its stated objectives of improving safety, health and welfare or the conditions of workers. In fact, what it's done is just improve the conditions for pimps and brothel owners. And we would encourage councils to push back because prostitution is harmful to workers in the community. The association of prostitution with alcohol and drug abuse, sexual abuse and violence means that we're sentencing more and more vulnerable people to an unacceptable situation. I mean, how can we be serious about reducing sexual violence against women when the state legitimizes the sexual abuse and exploitation of vulnerable people? And that's why there is a healthy stigma against prostitution, and for good reason. There was supposed to be a review of the law in 2018, but it was never done. There's no intention for it to be done, according to the Ministry of Justice. So we actually commissioned some research to review the law, and what we found was quite concerning. Firstly, health and safety violations. There's continuing health and safety violations, including coercion into unwanted sex acts, high levels of violence, physical injury, unsafe sex, and exploitative practices such as long working hours. Violence is a risk every prostitute takes. Assault, rape, strangulation are not uncommon. What other business or sector of society that you deal with in New Zealand would tolerate this? And yet the sex industry is sold to us as a success story. Where is occupational safety and health? No other work employment sector has a risk factor where rape is considered an inherent part of the work. And why would we want a family member to be in a type of work where there is a 35% chance of being sexually molested? In other words, forced to accept sex from a man they didn't want to. And this is fueled by increasingly violent pornography and a notorious drinking culture. Punters frequently enjoy hurting women. Overseas studies show that some men think raping a prostitute is not even possible. And as a result, studies continue to document depression, post-traumatic stress disorder, anxiety disorders, dissociative disorders, and bipolar disorders in women involved in prostitution. Yet New Zealand's official health and safety manual for prostitution advises prostitutes to identify potentially dangerous situations and to devise strategies to protect themselves. The Prostitutes Collective stated openly in 2016 that it was impossible to wipe out violence in the industry. And there's been low rates of reporting and prosecuting violations. Fewer than 20% of those who had been physically assaulted reported it to the police. Since 2003, there's been a handful of prosecutions for coercion, usually committed by the pimp, of course, despite repeated reports that it happens frequently. The black market is still here. The industry realities of gang involvement, child exploitation and internal trafficking that are largely denied or ignored by the Prostitutes Collective. The Ministry for Children at the time confirmed no funding had been made available to tackle underage prostitution. And there's a lack of support for exiting the industry. No resources have been provided to support women who want to exit the industry. When the law reform was being debated, it was promoted as helping to prevent entry and facilitate exiting. But the Prostitutes Collective does not even support that approach. Brothel inspections were mandated, but they're not happening. Over the last decade, only 11 brothel inspections were made across the whole of New Zealand. And there's been a failure to implement the changes from the review in 2008. 28 recommendations made, only 11 were followed through, and anyway, 17 were ignored. So, despite dangerous conditions continuing, New Zealand's prostitution law reform has been praised, particularly overseas, as beneficial for the women involved. The main reason for this is that the conversation has been dominated by the Prostitutes Collective, which is just a lobby group who government and unfortunately councils, including advice I've seen by your council, have relied on overwhelmingly for information regarding any issue related to prostitution. But the Prostitutes Collective don't provide support for those wishing to exit, has no official contact with the black market, plays down the industry-wide realities of violence and exploitation, denies the existence of underage abuse and internal trafficking, rejects the voices of women who have exited the industry, and amplifies the voice of pimps. They've always advocated for normalising prostitution as ordinary work. How many of you...
Apologies, another 10, we've just run over time, but you're welcome to wrap that up if you can quickly.
Okay, yeah, sure. Our recommendation is the council do not liberalise the existing bylaws in any way, especially keep it out of sight of families and children. And we would also encourage the council to remove the brothels out of the CBD. And just finally, I would just ask that you have a forum that allows for former prostitutes to speak freely. They will tell you how prostitution has wrecked their lives, that their troubled upbringings attracted them to prostitution. We need to help people get out of this industry. We need to prosecute the buyers and help prostitutes out of the industry. That's probably a viewpoint you haven't heard yet, but we need to hear it.
Awesome. Thank you very much, Bob. I appreciate
Thank you.
taking time to speak today.
Cheers.
And all this. Thanks.
Thanks.
All right, moving on, next we have Ali Marie. Oh, should we go, sorry, we'll go back to Janet from the Women's Declaration International in New Zealand. Janet, have you been able to sort out the muting problem? Hopefully. Yes, for
She's not on the meeting.
I've just spoken to Janet before and she's having trouble with her Zoom link, but if it doesn't, we get to the end and it doesn't work, I'll just get her to do a call through my channel and you'll still be able to hear her.
yeah,
Okay.
I mean, it sounds like we'll try and make it work regardless. But again, we can move on to Ali Marie Diamond if we have her here, and then we'll try and sort that out later on. But thank you, Jennifer, for allowances. So welcome, Ali Marie. If we have you here, just there we are. Hello.
Hi, can you hear me okay?
Yes, you hear you well. So you've got 5 minutes, like everyone else. If you feel like you want to allow time for questions, just be cognizant that that'll be inside the 5 minutes. So it's up to you how you want to use the time, but go for it.
Thanks. So ladies and gentlemen, thank you for having me here today. Sorry I couldn't be with you all in person. My name is Ali Marie Diamond. I am representing Wahine Toa Rising, a New Zealand registered charitable trust committed to upholding the dual heritage of Te Tiriti and supporting Wahine and Tamariki affected by trauma, violence and exploitation in the sex trade. We advocate for legal and policy changes to protect those at risk of exploitation. Today, I speak to oppose any changes to the current Brothel Control Bylaw that would allow the expansion of the sex trade operations in Queenstown and Wanaka. But before I do, I would like to draw your attention to the report of Reem Al-Salim, UN Special Rapporteur on Violence Against Women and Girls, presented last week to the United Nations Human Rights Council. Ms. Al-Salim makes clear what Wahine Toa Rising has been saying for the past 5 years, that prostitution is a system of exploitation and violence. She makes particular mention of the ways that the New Zealand decriminalised system has led to more exploitation and violence towards prostituted women and less accountability for those responsible for it. I urge you to take the time to read this report that was included in our submission, especially the recommendations she makes on pages 17 to 19. I also want to acknowledge that I am not local to Queenstown or Wanaka. My experience is that wherever the sex trade operates, the harms to the women and young people exploited by it are the same, and the same vulnerable groups are its target. Poor, marginalised women and young people, often from ethnic minorities, and as Ms. Al-Salim says, the prostitution system sexualises and racialises poverty. So with regard to the proposed brothel bylaw, regardless of how many brothels are operating in your district currently, expanding areas where brothels can operate and permitting them to be located at or below ground level will only increase opportunities for trafficking and exploitation, harming individuals and the community, a harm that the QLDC itself acknowledges but does nothing to prevent or alleviate. The Prostitution Reform Act 2003 is outdated and urgently needs review. As mentioned, the recent report by the UN Special Rapporteur on Violence Against Women and Girls criticises New Zealand's decriminalisation approach for aiding traffickers, boosting sex tourism and expanding the prostitution market. This approach has not reduced unsafe sexual practices and has actually increased violence against women and girls. Your own counsellor, Lisa Guy, has expressed concerns about the coercion of young people into sex work, noting the targeting of rangatahi with promises of easy money. There is little faith that all SUBs are genuinely owner-operated, with anecdotal evidence suggesting otherwise. The proposed bylaw changes will only exacerbate the inherent harms of the sex trade. Therefore, we support retaining the current bylaw, flawed as it is, to prevent further harm. Specifically, we support keeping brothels at least 100 metres apart. No changes to signage regulations, retaining the prohibition on brothels located at or below ground level. Regarding the size of permitted activity areas, we support option 3, which keeps the areas the same as the current bylaw in both Wanaka and Queenstown. Expanding these areas would only facilitate sex trafficking and sex tourism. The QLDC must refuse to enable the expansion of sex trafficking and take its harm prevention responsibility seriously. QLDC should fund and promote support services for those harmed in the sex trade, such as trauma-informed services, exit services, education and prevention resources. I urge the Council to listen to these concerns and act to protect vulnerable women and young people, especially those from Indigenous and minoritized ethnicities who are disproportionately affected by the sex trade. Thank you for your attention and for the opportunity to speak at this hearing. Wahine Toa Rising is ready to consult with you further if needed.
Thank you very much, Ellie Marie. We do have 30 seconds left if anyone has a question.
Not from me.
Okay, well timed and well spoken. So thank you very much for your submission. Appreciate it.
Thank you.
Thank you.
So now we will come back to Janet to see how things are going. Must be so stressful on the other side of this line. I really appreciate it. It's so scary when you can't talk. So feeling for you, but if you're in comms with John, do we have any update in terms of how she's getting on?
She's going to try to phone that.
All right, we're running in good time, so I think we'll allow a couple of minutes just to, well, another till 10:35, and then we can try Janet calling Jennifer and see how that works. Sorry. Yeah, trying to make it work for you, Janet. I apologize that I'm struggling with it.
Oh, look at that.
Janet, we can see a different version of you on the screen, which is exciting, but can you hear us and are you able to unmute?
Hello, can you hear me?
Yes, you can. Hallelujah.
Ah,
There you go.
right. I don't know I don't know if I've managed to put the video on or not, have I? Oh, yes, not really. Hang on, I'm not sure.
Really. It may not be an issue so long as we can hear you, then it'll be all right.
Okay, that's cool. I'll just talk. I managed to get on my phone finally because the computer wasn't working. Thank you.
I'll just remind you that you have 5 minutes to speak, and if you wanted to leave any space for questions, that'll be inside the 5 minutes, but it's up to you how you want to use it. So we'll start your time now.
Thank you very much. Hi, I'm Janet Alexandra. I'm representing the Women's Declaration International, the New Zealand sector of that. The Women's Declaration International has been formed to protect the rights of women and children, particularly those that are guaranteed by the Convention on the Elimination of Discrimination Against Women, CEDAW, and we're promoting equality and sex-based rights for women. We're opposed to prostitution because we do not see that as work like any other. A woman's body is not a workplace, and it is inherently violent towards women. And a lot of very young women who are actually children have also been and are being harmed by prostitution. So the purpose of the Prostitution Reform Act was to, first of all, the most important good purpose of it was to stop the prosecution of women in prostitution, and that's, I think, why it got passed, because that was only fair and just to do that. But it had other purposes as well, which was to protect women from violence and exploitation. And of course, it made any exploitation of anyone under 18 illegal as well. So the purpose was to make sure that children were not going to be exploited in prostitution at all. Now, this purpose has been shown to have failed. There was a Ministry of Justice report in 2008, which listed statistics about how violence is happening towards women in every sector of prostitution. And whether it was the street prostitution brothel or their sole owner operated brothels, that they all had plenty of violence. And as we all know, there have been a number of women who've been murdered who in relation to their work in prostitution since the Prostitution Reform Act was passed. So that's a failure. And also the 2008 report showed that most of the women in prostitution actually want to leave, and other reports, international reports, have shown that too. And there was another report in 2023 by Pitt and Johnson, which also outlined the failures of the Prostitution Reform Act to achieve its aims, and that it has shown that black market participation was rife, that there were health and safety violations, increased numbers of women and children in prostitution, lack of support for exiting the industry. There were no really brothel inspections happening, even though that's mandated in the Act. And and also some recommended changes from 2008 never happened. So the Act is a complete failure. So I don't think that the council should feel that it has to kind of keep on expanding prostitution in order to be somehow resonating with the Act, because the intentions of the Act are not working because, as a result of the provisions of the Act anyway. So the council would be better to look at the intentions, which are to prevent violence against women, to keep women and children safe. And that is how it should base its decisions. So we're opposed to any expansion of prostitution in Queensland, and we therefore want a no change, and we want the option 3. So that's the main things that I wanted to say, that I believe eventually the Prostitution Reform Act will be reviewed and reformed because of its failures, and the council in the meantime should be very aware of the human rights of women and children and our obligations under international law as well to protect those. We do not want Queenstown to become a sex tourism destination, which would mean there'd be a lot of increased trafficking of women into prostitution if that happened. And I think the council should bear in mind its responsibility about that. That's all from me. Thank you.
Awesome. That's well timed, Janet. There's about 20 seconds left, but I'm unsure.
Okay, thank you.
Thanks, Janet.
Thank you.
With that, I'd like to conclude the hearing of the submissions as we move forward to the deliberations. Does any of the other councillors believe that there are any grounds to exclude the public from the deliberations?
No.
No. So deliberations.
No resolution needed, so
No
just conclude the hearing, and I would recommend that you pass over to Carrie as the reporting officer to perhaps and she will help you work through the decisions you have to make.
Okay, over to you, Carrie. Appreciate it.
You Councillor Cocker. Just really briefly before turning it back to you, go through your deliberations. Effectively, what you will have already read in that hearings panel report is that we're looking for a recommendation from the panel to council on, first and foremost, proceeding with the bylaw to regulate this activity. And if the answer to that is yes, what changes may be proposed to the current bylaw. And so that's then going through for changes that were proposed. So that's the size of the areas, the purpose provision that was proposed, the removal of no brothels at or below ground levels. And the fourth change that was proposed, sorry, it's not a change, was confirming in your recommendation to council, no change to the signage provisions in the bylaw, as well as the 100 meters distance between brothels. So we can run through those in order. It's probably the most kind of organized way to do it, but happy to turn it over to questions that from councillors to guide your deliberations.
Yeah, well, I mean, I guess if there's any burning questions, we can start with those and then move through as you recommended it.
I've got a couple of questions.
Yeah.
Where was I? So just going back to, there's a definition of small owner operated brothels. It's not specifically defined in the bylaw,
Correct.
current bylaw or the proposed bylaw, but I think it is covered in the Constitution Reform Act. Yeah. But the definition that we do have in the bylaw, proposed or draft bylaw, that is more just generally for brothels themselves. That covers a small owner operated brothel as well, isn't it? Yeah. I wondered how the home occupation business arrangement, that is also explicitly covered by that definition, would it be? That's the question I had.
Sorry, so how the definition of SUB interacts with our home occupation?
Yeah.
I mean,
So home occupations are covered under the district plan.
so I'm speaking generally here because it's different depending on the area you're in, but in general, council's district plan provides that home occupation means that only one person may be living in the house. If there's more than one person living in the house, it's not a home occupation. So if you translate that to a SUB, what would be permissible is one sex worker living in the location and 3 not. There's also restrictions under the number of car movements per day.
Right.
And parking. I think it's 10 vehicle trips per day. This is again generalizing because it will be different on areas.
Yeah, sure.
There's also a restriction on the maximum floor area that it can occupy. And there's, it probably doesn't apply here, storage of any materials related to the activities. So I don't know if that provides a baseline effectively of the interrelationship there. Do you have anything to add on that in terms of what our home occupation provisions say?
Can I just clarify something? Because my understanding with the home occupation with that one person is that because they have a home occupation. So you can actually, you can have more than one person as long as they live at the address. And you can have up to one person who doesn't live at the address.
So I might have got back to front, but I'll read it out. No more than one full-time equivalent person from outside the
Yeah,
household.
so
Shall
as
be
long as,
employed thank you.
yeah, so as long as
I
you
got
live
that.
at that house.
So it's the premise is flipped. My apologies.
No, that's
Is
okay,
that
just to clarify.
You, in this situation, where the limit is 4 to meet the definition of a SUB, you could have, yeah.
So I guess my question, what I'm trying to explore is whether someone is operating under that home occupation model, whether or not it's allowed at the moment, but if they were to consider that, does it then meet the definition of a brothel so that it would be covered by this bylaw, which then would make it under the current draft bylaw not allowable?
Under the current bylaw, a SUB is included in the definition of the bylaw, so it's not permitted outside the permitted activity areas. Correct.
I guess the word I was getting, or not tripping over, but pondering, was where it says in the definition, a place that's habitually used for that purpose. If it was incidental to the fact that someone's living there, how does it then fall under the bylaw?
Yeah, Andrew may be able to speak to this in more detail, but
It's a tricky question.
enforcement does get tricky in this, regardless of the activity you're dealing with. my understanding would be that the situation that it relates to in this scenario is more to do with commercial accommodation, is not the residents habitually, yeah. But he can speak to the difficulties in drawing that
Effectively, what
distinction.
I understand your question is when would the threshold of habitually be met?
Right, yeah, frequency.
Yeah, from my perception, we haven't had to test that. That's number one. So we can't give a firm answer on that because everything needs to be tested to be able to give an accurate indication.
Yeah.
However, in the interests of your question, that if somebody was advertising and it was readily or always available from that place, then we'd be considering that habitual.
Yeah. Okay.
But the threshold would be quite easy to meet.
Yeah.
In my mind.
So there's not really the, ground up to that where a home occupation perhaps wouldn't be included under this definition in the bylaw, is there? That's likely to be included if it's being used for that purpose.
Yeah, if it's been utilised for that purpose, that would be captured by this bylaw.
I also had a question about the complaints that have been received. So the report, I think, mentioned 8 complaints, of which 6 were determined to be valid breaches of the bylaw. The question I've got is what times of day, whether you know this, what times of day were they and what locations in the district were they? Were those 6? Can you recall?
So as he's got some detail, my recollection of them when I've dealt with them has been early hours of the morning and in residential zones. So the breaches were to do with location, so operating outside of the permitted areas.
And to be clear on that, as the report outlines, this is the reason why we've highlighted that some of the reports of infringements weren't actually infringements of the bylaw, is this that out services where the transaction is arranged elsewhere and occurs at a different location again, that's not covered by the bylaw. Would it be covered by a district plan?
Yeah.
That's
and I guess, do you know the nature of how those complaints came about? Were they, people knocking on the wrong door or?
Yes, some of them were related to people being affected by the activity in the context of getting the wrong address early hours in the morning, drunken kind of behaviour and concerns around their own safety and their family safety, that kind of element.
That's a question.
Would you have any questions?
I don't think I've got any questions at this stage, although maybe actually, so this is my understanding, so I know we've done some workshops on this, but if it's not a zoo, you can just operate by yourself at home?
No.
No, okay, so you cannot, okay, so that it is just in that area, even if you were, but explain to me the arrange somewhere else situation, out services.
So that's where a sex worker is engaged to visit a client at a specified address and the transaction is initiated somewhere else.
Okay, all right, sorry, all right.
That's permissible.
So sorry, the other clarification there is that they are not the sex worker's premises.
Okay, so it's either a hotel or you
Generally speaking, commercial accommodation.
Or you might even go to the person's down the road.
Well, if it was the person's habitual residence, then it would be a suit. And it would be
No, sorry, the client's habitual residence.
Yes.
Yeah, there's no situation where the habitual resident of the client ends up becoming a suit because of that.
Not least that, well, no, the other one's paying, but no.
Yeah,
Okay.
really stretching the definitions. All right, happy to move to the structure that you want to leave with, in terms of going through the changes of the agenda amendments. That's how you want to.
Well, I mean, I don't have a particular agenda aside from going through the changes proposed and getting the recommendation for each from the panel. So if you want to start with the preliminary question before moving on to changes to the current bylaw, confirming that it is the panel's recommendation to council to proceed with the bylaw to regulate the activity.
Okay, so.
I'm well, can we
Yeah.
just talk about it? now?
Yeah.
So I'm happy that the bylaw is still the correct tool
Yeah, so the
rather
amended,
than the move into the district plan.
yes, so there's sort of three options. We can either stick with the bylaw as is, we can make the changes, which was updating the new purpose. And was it adding reference to the district plan? Am I correct? And
So I was sort of dealing with this as a threshold question to answer yes or no, and if we answer yes to proceeding with the bylaw, then we can go into those proposed changes.
okay, so we first need to discuss whether or not we want to change the existing.
And you're
So
right,
what I'm
there's
saying is-
three options there. Well, there's regulate via bylaw, or choose to regulate through the district plan.
But then, I'm just seeking clarification around any changes to the existing bylaw. Would we first need to agree to make changes to it before discussing those, or?
No, I think I agree with Carrie in the sense that we decide if the bylaw is the right thing, and if it is, do we make changes to it or not?
Awesome.
That's the way I had it
Great.
in my head, but.
Yeah, me too.
I'm happy to be
Just making
challenged.
sure that you're knowing what.
So my original thing was, I am still happy that we keep the bylaw.
Yeah,
Yeah.
okay,
Yeah, I'm in favour of keeping it under a bylaw as well. I guess, the point's been made that it could be considered a business like any other business, but there are some slight differences in terms of, especially if you're looking at home operated small businesses, is that the hours of operation are quite different to a standard home operation. And the concerns that we've got over, the complaints that have been raised have indicated that might become a bigger issue if it was dealt with under the district plan. So for those reasons, I'm satisfied that bylaw is the preferred method of dealing with this.
yeah, I also share those views. I think we've had an overwhelming amount of submissions, really highlight the importance of looking after the health and safety of women in the area, and that being far more about the act more so than location. And I think we have plenty of support to justify that the bylaw is has general support. So do I need to make a resolution, Jen?
I don't think that's
So we-
necessary at this
discussion.
point, because the recommendations at the beginning of this part are
It's covered in there, isn't it, in the
you
overall.
know, receive written submissions, recommend to council final form of the bylaw. So until we now go through any changes the panel may or may not recommend, I don't believe you need to make a resolution. So we move to the first area of proposed changes was the size of the permitted activity areas. And so that's where council adopted to consult on a bylaw with slightly expanded activity areas.
So that was based on, I think the original proposal, you had slightly larger areas proposed, well, bigger again near the whole town centre was put forward when full council considered going out for consultation. And with those three options, one was to stay as it was, two was the intermediate option, and three was the bigger, I don't know whichever way those options are. So when the full council just considered that, we arrived at or landed on the intermediate option. We had slight expansion from current, but not as big as the full town centres. And I remember thinking about that at the time, and I was satisfied that was a good option for the consultation, and I'm still satisfied that it's probably the better option out of the three.
Yeah, this is an interesting one because I agree with everything that you've said, except no submitters agreed with this.
So the reason
So where does this, how does this sit in terms of?
Well, the LDA requires that council is required to consider the submissions it received, but it does not legally required to adopt the positions made by the
Yeah.
submissions.
And I guess to your point that you made earlier, this is not a sliding scale. We came in at kind of, I guess, the middle ground, and everyone is still on opposite ends.
The reason that I'm still, with that frame of thought is that I mean, a lot of us have taken into account the submissions that we've read and heard. I think the majority wanted no areas at all. But I think under the situation that when we need to be able to provide some area for this work to be carried out legally, it's obviously there is some demand for it, and the fact that we've had complaints that have breached the bylaw indicates that this, there is some call for the services that are provided. And I think we have some responsibility to allow areas where the type of work can be carried out legally. And that also provides some protection to the people that are involved in the industry. I've already heard that it's difficult for some people to raise any, the exploitation or the concerns that have had because they're afraid that they're operating outside the bylaw and that will bring consequences. But the fact that we've got no brothels at the moment is, I think, indicative of the fact that the area is so small, it's quite hard to even establish in the area that we've got. I mean, we're only increasing the area slightly, but it does provide more chance for some premises to fall within that area to be able to operate legally under the bylaw, which then, like I say, then affords more protection under the Prostitution Reform Act for people engaged in the industry. I guess that's where I've got to.
Yeah, so share a similar viewpoint, although I don't always want to go to compromise as an answer. I do understand the intent of liberalising to the district plan, but I don't think that that really gives effect to the overwhelming submission or a lot of the sentiment around the protection of women. And so I see the slight expansion of the CBD allocations as being an acknowledgement of that sentiment and aligning our duty to conform to the PRA and ensure that we have the responsibility to create the right space for it.
Yeah, I agree. It's just commenting that even though I still agree with the option one as well, in terms of that, to me, it still addresses, we're never going to get agreement because there's such a wide spectrum of things, but this does address increasing the area somewhat, so there is more opportunity, while still actually keeping it relatively small overall in the district. So I'm happy to keep it as option one.
Option one is supporting the recommended.
That's the recommended what went out, yeah.
What's consulted on.
Yeah. Is that where you're at, kind of?
Yep.
Yep.
So do we move to?
I'm happy to cover up all of the proposed changes and then unless you'd like to.
No, you go.
Yeah, so the next change proposed was the addition of a purpose provision to the bylaw. It currently doesn't have one. It's open to the panel and councillors to make changes to that. You'll have read in the hearings report that again there was objection to it, but no substance provided over to what the changes people wanted to see to it.
So that was highlighting the intent with what this bylaw is to support the purpose and objectives of the PRA, just to acknowledge that this is there in order to meet our requirements as a local authority to the Act, and as well as I think you can go through it if you want to. Do you have any questions?
Yeah, I guess something came up when we talked about it at the full council meeting, and part B of purpose of 2.1, the phrase where it says meets community demand. There was some discussion about it at the time. Well, it says community demand in the,
Market.
oh, well, the draft that's in the report says community.
Huh, I'm reading meets market demand for services and addresses communities' concerns.
On page 27 of the hearing agenda.
No, I'm on page 16.
6,
What page are you on?
27, the
27 and read.
the marked up version of the old bylaw. Anyway, so the question I had, or definitely I thought community didn't need to be in there, community demand.
It might be an error, is that an error? The community demand, so in the report it actually says market demand.
Yeah.
So this is the draft bylaw.
Okay, well, I am sure you're alluding to either, or it doesn't really seem sufficient to include.
So I guess what I was going to say was, the meeting demand, whether it's market demand, I didn't think community demand was the right word anyway, so it's fine. But meeting demand, I did have cause to think about that more after we discussed it in the meeting, and I wondered whether that is the right word. In terms of meeting demand, it makes it sound like you're going to cater for all demand, where I was wondering whether we couldn't use words like cater for demand rather than meeting it. Whether that makes any difference.
Just as a point of clarification, as a formality, if there is an error in the hearing report, it's my view that what the draft bylaw says that's consulted on is what went out to the community. So it is point of community demand. Yeah, but I think that the sticking point, as I recall, Councillor McPherson at the meeting, was around the use of the word demand.
Well, meeting demand. I think
Yeah,
is the-
and so it's open to the panel as well as councillors to deliberate on whether or not removing that altogether is in line with the intent of the bylaw. So enable community sexual service providers to operate within the district in a manner
That addresses community concerns and sensitivities.
that
Well,
addresses.
So there is obviously, well, potentially demand. I don't think we need to worry about trying to meet that demand, but we can provide a bylaw that caters for it. So I guess where I'm coming at.
Right. Meet implies,
Meet implies that
matching.
that's part of the goal of.
yeah,
I understand, I totally, I see what.
so
It's up to, private or business to try and meet that demand, as long as it's being catered, I guess. That's what I'm saying. It's not up to us to try and meet it, provide something to meet it.
I guess how I see it is that it is our responsibility to enable commercial sexual service. That is, we have an obligation to do that because this has been legalised. So it is our responsibility to enable commercial sexual services providers to operate within the district. That I feel very comfortable with. I agree we potentially don't need that meets community demand. But we could keep in there addresses community concerns and sensitivities, because I do feel like the meets demand is actually captured in enable commercial sexual services providers to operate within the district.
yeah, I agree. So
Does that make
Yeah,
sense?
so if I read out what you're proposing, it would be enable community sexual service providers to operate within the district and address community concerns and sensitivities.
in a
In
manner
a manner that addresses
addresses.
community concerns and sensitivities.
Okay.
Does that work for you, Gavin?
Yeah, I think that's okay. Yeah, I mean, you're right, by enabling providers to operate, that's then catered with the demand anyway.
Yeah.
And then, in a manner that meets, or a manner that addresses.
And then it's up to the individual providers to meet demand.
As they see fit. Yeah, are you happy with that, Chair?
Any more discussion on that one, or I'm happy to put that?
I'm happy to-
No, I'm happy with
very
it.
supportive.
I'll just, Jane, I'll message through you the wording on that so you can that through. So the next proposed change was to remove the restriction on brothels not being allowed at or below ground level. And as the report says, the rationale behind this was to provide opportunity for brothel activity, given concerns around the restrictive nature of the bylaw. Happy to turn it over to you guys to discuss.
I'm not gonna lie, I definitely missed this part in the workshop and the meeting. That it was gonna be ground level. What were the reasons behind, like, so that's just to also, I guess, enable a larger area? I mean, we don't have many underground options here, do we? Anyway,
I mean, the entire discussion is theoretical when we have no registered brothels in the district.
or that much opportunity for it to be underground. Anyway, like,
Only comment I can make on that is that there are some premise, I don't know the number exactly, but
I mean, it's not many though, is it?
I mean,
there's probably, it's hard to know, some stores have space which they don't utilise for the sales, but for managing stock and those sorts of things. So there's probably more space than what we generally understand.
Yeah, okay. All right.
the recommendation is to remove that. I personally see that, having that restriction of ground level and below is addressing the community's concerns and sensitivities more so. I don't see necessarily, much of a reason to remove that from.
So you're saying prefer that it remains as the current bylaw?
Yeah,
With an exclusion for ground below.
an exclusion for ground and below.
I think there were a number of submissions were in favour of retaining that restriction.
I can imagine just in terms of the sentiment from the community, with access to eye level and walking past and all of that. I don't see I can see how it's a very, important aspect of ensuring it was done sensitively. So
But yeah, I don't, I'm happy with that.
keep it. That's it.
So retain excluding ground level.
Okay.
So, ground level or below. So it would only be second story or above. Be happy with that? How do you feel about that?
Yeah, I think I am.
Well, although let's just talk about it a little bit, because there is a reason that we changed it, or it was recommended to be changed. So, and even if it is at ground level, there can't be any, like, we can't be like, it's not going to be like walking down Amsterdam that it can be on show or anything.
It could be.
Could be, okay.
Well, the sign is.
There's a signage on your
A
door.
signage,
but
yeah.
Beyond the signage, you'll have windows on your shop.
You could advertise your service.
So don't think about signage.
Yeah.
If you walk past, so just to keep in the context, you walk down the street and you look through the window of a shop.
Yeah,
Whatever services in there is what you see. I don't know how they'll operate,
yeah.
but there isn't additional restrictions proposed or anything around managing what
Okay.
is seen through the window.
And you can imagine how that would
Oh,
create.
yeah, no, so that I don't, yeah, I'm happy to keep that out of it, the ground level.
The
I
key though
guess-
was that it created more opportunity within the same
Same
space.
space, yeah, so you grew the opportunity, but didn't have to increase the space. But then I guess we had this unintended consequence that potentially it could be on show, which is not necessarily what but where I guess the issue, I don't know, maybe it's not. Because, yeah, I guess the problem is if we don't have it at ground level, but we've included houses that are single level, and actually we haven't included those houses at all.
So does that provision also become the case for residential SUPs? That's the case. Well, this
That's
bylaw,
all, that's all on the
this
same.
bylaw isn't enabling SUPs anyway,
Outside of this area.
outside of that area. Is it more the street level more so than underground?
For me, it's more the street level than underground.
Yeah. Is that also shared by,
Yeah, I think so. I mean, when we're walking around our CBD at street level, we don't want to see boarded up windows, or windows that are completely covered up. We like to see commercial spaces that are open.
Yeah.
The below ground level isn't as much of an issue for me, but I do think the ground level might be an issue.
Yeah.
So can we modify it to allow below ground level, but not at ground level, below and above, but not at? Is that an option?
So the option being to restrict at
Ground level only.
That's completely an option. I guess I'd take a couple of step backs just to remind councillors that the reasons for increasing the opportunities was the perception of restrictive under New Zealand Bill of Rights Act. And so that's why these opportunities were increased. Just to explain the etiology behind it, it wasn't sort of done in a, oh, let's, it was to try to create, but I totally understand the discussions that just occurred. No, my opinion is that it is within the scope of the statement of proposal to reach the halfway ground there because it was consulted on, and you're suggesting splitting it down the middle. So I don't see that there is any risk in terms of the scope and the statement of proposal on that front.
Cool. So number one, we've got a bigger area in general. Number two, would open it up to below ground level compared to what the current bylaw says, but still have that ground level restriction.
correct. That's how I see it.
I don't see any issues with recommending that on the scope front. As we've discussed, we've got very little data to go by here to provide you with evidence, unfortunately.
All right, I think, but apologies, I think we've got consensus on that point. So if you share that, we're happy to move forward with that. So
It's a double negative.
Yeah.
So you're proposing to remove the restriction on bylaws operating below ground level, but maintaining the restriction on bylaws being unable to operate at ground level.
Correct. Getting there, we're moving forward.
So the final one is actually a confirmation in terms of there was no changes in the statement proposal proposed around the signage provisions in the bylaw. And there was also no changes proposed around the requirement of 100 meters distance between brothels and the bylaw. Probably repeating myself on what I just said, we have no registered brothels in the district right now within which to provide data on, the operation of distance provisions or signage provisions. So that is the basis behind which no changes were proposed on that.
My comments on that signage, I don't have any issue with, but I guess the 100 meters, and I guess this might be an answer that so some of the things that we've done, like we did consult on going to ground level, we've just pulled that out, which means I guess we've lessened it slightly. The 100 meters does put quite a big restriction on quite this small area, and I know we've got none at the moment, so we're talking quite theoretical, but if we decided, could we remove the 100 meters?
Hypothetically, I don't think there's a risk there in that because of what I said, we don't have any registered brothels.
Okay.
Who we understand that rights would be affected by the change in proposal.
Because that's something that we could do to say that then we would allow
Yeah,
because the whole point of this was that we were at risk, that we were being too restrictive. So we've expanded slightly. But removing the 100 metres would allow more opportunity. I know this is opportunity, because currently it's nothing anyway, but
And there's the middle ground potential as well,
that we do it to 50 or something like that.
just that, yeah, there's options.
What are your thoughts on that? Because I do feel like the 100, given that these are quite small, like I know
Yeah,
it's
I-
doubled in
just-
size, but they're still quite
it's
small.
Very small memory back on this. It's never been a real significant point, but in the last bylaw, there was some talk about trying to restrict a line of them.
Yeah.
So that's the purpose of of how that rule would be.
But
Why
so then 50 might be a slightly,
Yeah,
that might be a slightly,
we haven't done analysis around that, so we don't have any.
because we don't
so
have
I
any,
can't
right, yeah.
Comment around the effects of it or not. But 50 for, as you pointed out, would create more opportunity, no restriction would create more opportunity.
Hmm.
Currently, it is 100 metres.
I guess you're right though, but no restriction would then potentially create a line, it could create a row, which we also didn't want.
yeah, I think I go back to Ed's point is that we don't have information to vary.
Yeah,
To have a policy back basis to vary, yeah.
So then are we happy to leave it there or?
I guess I'm a little, the reason that I bring that up is because well, we had to renew this anyway, because we're at the 3-year point or something, but the whole point of expanding the area slightly was to allow more opportunity, because there had been commentary around that it was so restrictive that actually everyone was operating illegally anyway. So we have done somewhat, but I do think maybe decreasing it to 50, maybe not removing it completely, might then alleviate some of that risk of us still being pretty tight on this.
Well, the risk has just been legally challenged to not giving effect to the Prostitution Reform Act, correct?
Yeah.
I think that's, I've had a very strong sentiment to do, I don't know, it's always going to be hard to strike a balance, but given Carrie's point, the theoretical nature of it, given that we haven't got it, even if we had one, it wouldn't have effect until there was 2. Yeah.
Yeah, I'd feel more comfortable having something in there.
Yeah.
Whether it's 100 or 50, but the other item that was discussed when it came to the full council meeting, and it has been raised by at least one of the submitters, is the separation from sensitive sites. It wasn't included in the consultation, but
Yeah, and the reason behind that being with the size of the restricted area, if you were dealing with, for example, Hamilton City Council Brothel, where their permitted activity area is, the entire city, they obviously have more considerations in place around places of worship and schools than the size of the activity areas proposed here.
the only reason I guess to bring it up is that the area, I'm not sure about for Wanaka, but for Queenstown, there is a church inside the area. I think there's only the one, I think, that would be affected anyway, but it's currently in the same situation. It's within the current area, I think, anyway, isn't it?
But it is in the current area, yeah, so nothing's really changed there for them.
I guess this bylaw will be reviewed again in another 5 or 6 years, I imagine.
Correct.
Yeah.
My opinion would be that to go down the sensitive site track at this stage of the game would probably entail reconsulting.
Yeah, that's what I wondered. Yeah, so that's where I was, like you say, there's none at the moment anyway. Under the new bylaw, if we do get some brothels set up, then I guess when the review happens, the next review will be time, if there is an issue, it will be time to look at them.
And I mean, it is, as much as bylaws aren't particularly nimble, it's open to council to review a bylaw at any time.
Right.
Do you have a position on it?
On the
100 metre thing?
yeah. I don't think it makes much difference to me whether it's 100 metres or 50 metres.
Yeah, I know that.
And within the areas that we're talking about, they are such small areas anyway. Yeah, 100 metre separation is, and if it's only to avoid, a number of premises set up close proximity to each other, 50 metres would achieve that, potentially anyway. Final decision.
Out of all things, I honestly feel that there doesn't seem to be a need or any sentiment from the community submissions that we need to amend that in any way. So I'm happy to leave it as is with the current restrictions.
I'm happy with it as well. I just wanted to bring it up as could be a way that we could be seen to say, well, we are enabling more in this space that we're providing. So I'm totally happy to go with that. I just wanted to raise it and talk about it as an option. So
yeah, happy to leave where
it's not a thing that I desperately need, just wanted to bring it up.
Thank you. So is that all of the amendments that we're proposing?
And the non-amendments. I mean, effectively, we went for the whole bylaw.
The removed as well.
So if I summarize, for the hearings panel, it's recommended to go to council with the draft bylaw that was consulted on in terms of the permitted activity areas. That in terms of the purpose provision, that section 2(1)(b) is changed to read, enable commercial sexual service providers to operate within a district in a manner that addresses community concerns and sensitivities. Have a go with this at or below ground level restriction. Maintain the restriction on brothels not being permitted to operate at ground level within the permitted activity areas, but remove this with respect to below ground properties, and confirming no change to the provisions around signage and the 100 meters distance between brothels.
So one other little tiny typo as well, I spotted. On the interpretation, the definition for brothel, it says means, I think it should say any, but it's got an end in there. I think it should be means any premises.
Sorry, purpose provision.
Number 3.1 on the draft bylaw.
Yeah.
I think. It says, so under interpretation, 3.1 brothel means any premises kept. The version I've got says means and premises.
Yeah, that's.
I think it's just a.
Keep it such eager lines.
A D should be a Y, that's all.
3.1.
So I'm looking at page 27 with the marked up version of the bylaw.
Brothel means any.
Yeah.
We're looking for red text.
Thank you. I was,
Yeah.
It's probably been like that for long.
No.
Maybe 20, I don't know, forever.
So I think in the previous version it was right, in the old bylaw.
Oh, it was.
Yeah,
Right.
so it's just coming with that markup, I think. Anyway, it's all right.
So do I go with this?
Yeah, so the proposed resolution is the full consideration of the submissions and objections and determine the extent to which they are allowed or accepted or disallowed or not accepted, and recommend to council that the proposed Brothel Control Bylaw be adopted as amended.
I also have a recommendation received, so written submissions, and here's the submitters who wish to be heard, was on the hearings panel report.
Oh,
So receive the submissions
Receive all written submissions.
or written submissions.
yeah.
We can put that in
Yeah,
there.
okay, no, yeah, that's fine. Okay, so, yeah, it's as per page 7 of the agenda, with part 3, recommend to council that the Brothel Control Bylaw be adopted as amended.
We don't need to change the third one, it was just the one adding and the receiving the submissions.
Yeah,
It's
yes.
point 2.
Yeah.
1, 2. So we had note, number 1 note,
Yeah.
number 3 receive, number 3 recommend to council. Was there a number 4 as well? Was there amended?
No, we're just a final form of the Brothel Control Bylaw amended.
Right. Oh, okay.
Yeah.
Yeah. Okay.
Circulate some of it.
Yeah.
Or I think they generally-
Based upon consideration that be adopted as amended.
Okay, so just to clean this up, get to where we've got, I am looking for a mover and a seconder to 1, note the contents of this report. 2, the panel gives full consideration to the submissions and objections received on the draft Brothel Control Bylaw of 2024 and determine the extent to which the submissions are allowed or accepted or disallowed or not accepted. 3, recommend to council that the Brothel Control Bylaw 2024, based upon consideration of submissions and objections, be adopted as amended. Do I have a mover?
I'll move it.
I'll see that.
Councillor White and seconder. Thank you, Gavin. All those in favour?
Aye.
Aye. All those against? Motion carries. I will now conclude the meeting at 11:28 AM. Thank you, everybody. Stick around.